Good morning, everyone. My name is Emily Meyer. I'm with Bearing Insurance, and I'd like to welcome you to today's SESCO webinar on Virginia employment law updates. Today, I'll be covering new Virginia employment laws, which took effect in July 2026 and beyond, and it will include employer compliance requirements, policy impacts, and practical steps that organizations should take to reduce risk and prepare for upcoming changes. Our presenter today is Jamie Hasty from SESCO Management Consultants. We've been partnering with SESCO for many years, and since 1945, SESCO has been providing human resources and employee relations consulting services to organizations across the country. For those of you who are Bearing clients, we encourage you to take full advantage of the valuable resources and expertise available through your access to SESCO. Today's webinar is being recorded, and I will send the recording to all attendees following this presentation. We will also reserve a time for a question and answer session at the end, so please feel free to submit your questions in the Teams chat as they come to mind throughout the webinar. With that, I will turn things over to Jamie Hasty, Vice President of SESCO Management Consultants. Jamie, thank you for being with us today.
Thank you so much. Good morning, everybody. I know this is a very popular topic, and we have quite a few joining us today, so that's great to see. We do have a lot to cover, so as Emily said, feel free to use that chat feature as we go along with your questions. I'm going to do my best to kind of preempt some of those just based off of the questions that I've been getting from our clients and from Bearing clients since early spring when General Assembly ended and some of these law changes were announced. So you will receive a copy of the slides. And then, as Emily mentioned, Bearing does have a relationship with SESCO to provide its clients with some telephone and email consulting services as a member benefit. So feel free to utilize that as well if you have follow-up questions that we may or may not be able to get to today. So let's dive on in. Computer is working. So Virginia obviously wrapped its legislative session around March of this year. General Assembly is always in session. This year was a long session, meaning it was at least 12 weeks long. And at the end of our session this year, there were some pretty significant regulations that were enacted. Some of which have been tried to be enacted year over year, and they finally made it through, and others are new. So we've got a lot to look at, particularly when it comes to pay, hiring, paid leave, and restrictive covenants there. So some are going to apply very broadly to both public and private, as well as small employers over time. Not everything is effective July 1 of this year. There are regulations that we will cover that don't start until 27, 28, and sometimes even 29. So the biggest thing here is we want to be educated on what these changes are, how that may impact your organization based off the size, and help us avoid any missteps, which can obviously create employment law liability, employee disputes, complaints, lawsuits, and policy inconsistency there. So you all know me, the best defense is always good planning, great documentation, and training our leadership so everybody is on the same page to avoid any of those missteps. So high-level timeline here for us. So July 1 of this year, we had expanded wage definitions. We have wage transparency requirements. We have restrictions on asking salary or compensation history. These are fully complete changes. In 27, January 1, obviously minimum wage is going to increase. We are used to an incremental increase that started back in 2021. But this year we're kind of getting a larger increase. So it'll go up to $13.75. And then by 2029, it will be $15 an hour. July 1 of 27, paid sick and safe leave begins for what I consider a large employer. Large employer defined by both Virginia DOLI as well as federal DOLI is 50 plus employees. In May 1 of 2028, VOSH, Virginia Safety, will be implementing some sort of heat illness regulation. That's going to be important for businesses that have individuals out in the heat. So construction, agriculture, anybody that might be in a sales role, automotive industry, manufacturing, where it may be a certain temperature outdoors and indoors, may or may not have air conditioning units, mandatory rest breaks, that sort of thing. So those are not here yet. I don't know what those are going to look like, but just know that they are coming. December 1 of 2028, state paid family medical leave benefits are going to begin. We've got a few slides on that, so we'll talk more about that in depth. And then by January 1 of 29, the paid sick and safe leave, which is separate from paid family medical leave, will apply to all employers with at least one employee. So we got a lot going on here in Virginia, and this is just from this year. So it'll be interesting to see what they do next legislative session. So one of the big changes that's already in effect is what we consider a definition of wages, right? Historically, Virginia Wage Act has followed federal FLSA, that is the Fair Labor Standards Act, with a few small changes, right? So effective July 1 of this year, we expanded what counts as technically money owed to employees, right? That's typically hourly wages, salaries, overtime, prevailing wages if you're a federal contractor, commissions, tips, bonuses, piece rates, day rates, right? Once that compensation is considered earned by the pay plan, by the stipulation, whatever is tied to, if you do X, you get Y. They must be paid that. Okay. They must be paid that commission. Why is that important? Because oftentimes in certain industries, we have employees that, are on a commission or a bonus or what have you, and their pay plan is not written correctly about when the definition of when it is considered earned, and or sometimes businesses want to say, well, you didn't stay through the entire end of the month, so you forfeit all of the commission, all of the bonus. That's not going to work anymore. Okay. So pay plans must be clearly legally drafted. So any sort of non-discretionary bonus, spiff, commission, those sorts of things must have a signed pay plan. Okay, it can't be a verbal agreement. It needs to be in writing. Okay. So here are some immediate risk areas that we need to be mindful of. Commission pay plans that are conditioned upon, the payment is conditioned, on active employment at the actual payout date, whether that is monthly, quarterly, or annually. Those are going to be risk areas. Any sort of bonus or incentive plan that does not have clear earning triggers. Okay, again, if you do X, you get Y. Okay. So, it could be a tiered system. It could be hitting a particular goal or objective, attendance bonus, safety bonus, those sorts of things need to be very, very clear on when it is considered earned. Any sort of what we call clawback language. Okay. Clawback language is what we term as the forfeiture of the, commission, bonus, spiff, whatever it may be. If that is not specifically written lawfully or clearly explained in writing, you can't take those monies back, period. It's not going to happen. Okay. Doing so would open you up to a claim with the Virginia Department of Labor for a improper withholding of wages. Okay. Friendly reminder that anybody that is considered non-exempt, that could be hourly non-exempt or salaried non-exempt, that are eligible for overtime, and they are earning what we call a non-discretionary bonus. Non-discretionary bonuses are bonuses that are tied to hitting a metric. Okay. Goals, objectives, again, attendance bonus, safety bonus, those sorts of things. You do ABC, you get XYZ. Okay. those must be included for purposes of overtime. So if I'm giving somebody a monthly commission and they are hourly, and even if it's a small commission, but that individual is working overtime, maybe it's an hour or two a week. Overtime is calculated on what we call the regular rate of pay. So that's total monies earned divided by clock hours to get a regular rate. Where payroll companies sometimes do not identify areas of red flags or areas of liability is they are not calculating the additional overtime owed on the bonus or the commission. Okay. It's what we call premium overtime. So if you have additional questions about that, it's probably best to talk one-on-one so that we can look at specifically positions and what we've got going on with you there. So
We did have a question about this topic specifically.
Yep.
Someone to know if it included all hourly and salaried employees, and if there's a bonus program, does it have to be in writing with clear earning triggers?
Yes. Yes. These changes apply to hourly or salary. Now, if we're talking about overtime, that's only non-exempt. Again, they can be hourly or salaried non-exempt. But in terms of when a commission or bonus is considered earned, it applies to all employees. Okay. And then, Emily, the second part of that, I believe, was asking about a bonus structure in writing. Absolutely. Absolutely. If you offer bonuses that are tied to metrics, it absolutely needs to be in writing. Now, there's a difference between a discretionary bonus, right? Let's say, Emily, you're wearing blue today, and I want to give you $500 because I like blue and I'm in a great mood. That's at my discretion. You didn't know that you were going to walk in today and get $500. Okay, that's not tied in with these new rules. These rules apply to things that the employee is aware. If I do all of these things, then I will get these monies. And those should always be in writing. Absolutely. Because if it's ever challenged, I'm going to have to defend it to the Department of Labor, either federal and or state. So great question there. Friendly reminder, we do have federal wage and hour overlay here. So just because we are in Virginia, it does not replace our requirement to comply with the federal FLSA. And federal FLSA, in terms of non-discretionary bonuses, commissions, or incentives, has always been required to be included in the regular rate for overtime purposes. So this is your opportunity to check with your payroll vendor, right? Make sure that they are calculating the regular rate correctly, that anybody that might be non-exempt, overtime eligible, that may receive a bonus or an incentive, that it's being calculated correctly. Remember that your payroll vendors are not there to determine legal compliance. That is why it is incredibly important that you should have a wage and hour audit conducted by SESCO, by an employment attorney, somebody that specializes in wage and hour compliance, to make sure that we have folks classified correctly, that we are looking at pay plans and hours of work and getting everybody paid appropriately. That's important because federal wage and hour audits and even Virginia wage payment audits. So Virginia wage payment allows for them to circumvent federal altogether and go straight to civil litigation, right? So, but regardless, if Department of Labor sends you a notice that you're going to receive a wage and hour audit, they're going to pull 2 years of your payroll records, okay? And they're going to run their own calculations. They're going to argue exemption status, overtime, non-discretionary bonuses. Did we make improper wage deductions? Are our meal periods that were unpaid? Were they at least 30 minutes or longer in duration? And if there is not clear documentation on pay plans, hours of work, time cards, all of those things, there is a 2-year wage, back wage liability in addition to liquidated damages. So if they run the numbers or I run the numbers and it is, 50,000, okay, that 50,000 back wage liability automatically becomes $100,000. Okay. So Wage and hour audits are really, really important. You should be doing them at least no less than every other year. Okay. And make sure that HR, payroll, finance, ops, everybody's in alignment before we change pay practices. Don't create your own workarounds. Make sure that you are vetting those with SESCO. Okay. So if you have individuals that are on some form of incentive pay plans, audit those. Make sure that they're written incredibly specific. Make sure that they are including when it is considered earned, calculated, payable, and if there is a forfeiture via a clawback, that clawback is going to work here in Virginia. Okay. Anything that conflicts with our new wage payment rules, we got to pull out. Okay. We might be able to reword it, but it's got to come out. Okay. Also double check for that non-discretionary compensation for regular rate and make sure that managers are trained. You don't make promises about compensation. You don't change pay plans without vetting it with counsel. Okay. Because even the best intentions, because wage and hour is so complex, the best intentions and saying, oh, well, the person wants to go on salary. They don't want the overtime. They want the salary and the bonus, and, they don't want to keep a time card. That might be true. And it might be easier for them and for us, but that doesn't mean that it is compliant. Okay. So that's your practical step there. Another big change that took effect this July is that we are now required in every internal or external job posting for a new position, a promotion, or a transfer that we must disclose the compensation range for that position. Okay. How do we get that range? That range has to be set in what we call a good faith effort. Okay. So I'm looking at the people that I currently have in that role. I look at the budget, I look at the pay scale, I look at actual range for equivalent roles, I look at comparable support, I look at external market data to come up with that good faith range. It has to be listed in the job posting. Okay. So if I'm looking for an administrative assistant here in the Richmond area, I'm going to, have the job description, and I'm going to specifically need to say this position based off of education, experience, requirements of the job will pay between, and I'm just going to use random numbers here, $25 and $32 an hour, period. I have to be able and willing and readily prepared to pay somewhere in that range. Okay. What you don't want to do is list those job postings at starting at $17 an hour. Okay. Why? Because that's not a good faith range. Okay. So make sure that you are updating all of your job postings, that managers are aware, that we have to disclose that. Okay. Now, a lot of us use an HRIS system, and that might be linked with our applicant tracking system, or ATS, right? So job requisitions in there need to go through. You may have a careers page on your website where individuals can apply for very specific jobs. If you are accepting general applications where I walk in or I go online to submit a general application, but it's not tied into a specific job, right? I walk in and I say, hey, Austin, I want to apply for a marketing coordinator position at Bering. Austin's going to have to give me the range for that job. But if I go to Bering's website and I'm allowed just to submit a general application, I say I'm open to anything I might be qualified for based off of this resume. I don't have to disclose a position, right? Or a range for a position, because I haven't identified a position that I am applying for. So we talked about what a good faith range is. Again, what we should actually expect to pay for the position at the time that it has been posted. Yes, you can give broad ranges, but they need to be realistic. Don't say I'm going to pay between 50 and 80,000. That's too big. You're not going to generally have that large of a swing. Okay. It's got to be credible compensation. Okay. Because we can't use large ranges to avoid the transparent piece. This is why it is incredibly important also for you to have a solid, defensible compensation plan, labor grades, internal factoring, external market data to support how we came up with these ranges. Okay, that's something that SESCO does day in and day out. I'm currently doing 3 right now for clients. Okay, things that can impact that range. Maybe you have various locations throughout the entire state, right? Well, Northern Virginia market is going to pay very different than Roanoke or Virginia Beach, right? So if you are an organization that has multiple locations spread out in different areas, or different shifts, different credentials, each one of those ranges can be tailored for that location, shift, credential, internal budget, and market data. Okay, again, goes back to the importance of needing to have a solid actual compensation plan that is defensible both to the state and to the federal government, and it's best practice, right? That also helps us avoid any sort of equal pay concerns under the Equal Pay Act, right? And then we also need to be documenting why the range was selected before the job is posted. So here's just your quick little posting compliance checklist there. Make sure that there is a minimum and a maximum wage or salary range for every single position. Same process is going to apply to anybody that is transferring internally or is looking at a promotion. Okay. This is your friendly reminder that you need to make sure your job descriptions are updated. Okay. Offer letters are updated. Compensation ranges are updated. And they're actually reflective of everything that the job is doing so that we can justify that range. If you are working with recruiters or Robert Half or other temp agencies or online systems, make sure that all of those are updated as well. Keep copies of the postings and the range support in the event that somebody tries to allege it wasn't posted, I didn't know, they told me verbally one thing and then, offered me a completely different number that was not in the range. We have to be able to defend.
Marcel wanted to know what the consequences are if the pay range is not included.
So that's great because here we are. Here we are on this slide. There can be penalties from Virginia Wage and Hour. So typically, if the wages are not posted with the job posting, the employee or the applicant must notify us of a wage transparency concern. Then I have 15 business days to cure the opportunity. Okay. If I choose not to cure the opportunity within those 15 business days, that individual is able to file a wage and hour lawsuit against you. Okay. That would then go to Virginia Department of Labor and or civil litigation where you would face, attorney's fees, compensatory and civil penalties. Numbers could be all over the map. So I can't give you a general, if you do this, it's going to be $1,000 slap on the hand because it may be a heck of a lot more than that. So great question. So make sure HR, payroll, leadership, legal, everybody's on the same page here. Another big change is our salary history ban, right? So we cannot, effective July 1 of this year, ask or rely on somebody's wage or salary history in our compensation and hiring decisions. Okay. What does that mean? I can't ask you, what are you currently making? I can't ask you, what do you want to make? I can't check references and verify, were they making $25 an hour or $40 an hour? Okay. Any information on your application that's asking, look, I have to list, I work currently at SESCO management and my salary is blank. That's got to come off. The salary piece has to come off of your application. Now, if in the interview they actively volunteer it, okay, without prompting, great. Don't write it down. Okay. Absolutely don't write that down in your notes. Okay. Again, and this salary ban ties back into the wage transparency piece, right? Because we're moving toward offers of employment are based on the role, the market, our internal equity, the qualifications, and our documented compensation structure. If you do not have a comp plan, you need to get one, okay, to best protect the business. So make sure we're removing any sort of salary history questions from applications, screening forms, any sort of AI or automated workflows through your HRIS or ATS. Make sure that your managers are trained appropriately and what they can and cannot say. I'm going to give you some examples here in one of the next slides. Okay. They're not to ask about prior pay. Make sure our reference checks are also updated so that we're not, asking for wage confirmation. Okay. Use those good ranges. And you may also want to consider instructing the applicants not to disclose salary history or compensation history as soon as you start the interview process. So here are some examples of things we're not going to ask. What are you making now? What did your last person pay you? Do you have pay stubs that I can see? Right? Before we approve your offer, we need to verify your current compensation. Okay. So here's what we are going to say. We are going to say this position as listed in the job posting and as we have budgeted is between blank and blank based off of education, experience, skill sets as the job requires. Does this meet your expectations? Yes or no? That's all you're going to ask. Okay. That's all you're going to ask.
Kim had a question.
Yep.
They were wondering if pay range advertising includes tips, like $18 including tips.
Yes, you're going to need to say that it includes tips.
Okay.
Yeah. Good question. All right, let's talk a little bit about non-competes. This is not new for Virginia, but it has been slightly changed a little bit, okay? So we've already been restricting non-competes for what we call low-wage employees and non-exempt employees, okay? So if you've got anybody making less than, prior to July 1, it was about 83,000. Okay, you can't use non-compete for them. That amount is increased significantly. So any non-compete entered into, amended, or renewed on or after July 1 cannot be used for anybody making less than $126,000 a year. Okay, definitely if they are considered non-exempt, you can't use non-compete, right? Now, healthcare professionals may also not be required to enter into non-competes. Okay, so think about your nurses, your medical providers, i.e. your doctors, PAs, MPs, those sorts of things, okay? There also is a change sometimes when we discharge an individual. Let's say I had somebody that is a sales director, okay? And they are making above the new threshold. Let's say they make $150,000 a year, right? And they have a non-compete because they're in sales. And I don't want them to, go to my competitor and take all of my customers with them, right? That non-compete is fine as is. But let's say I need to separate that, that employee, okay? In order for the non-compete to still remain in effect for that high-waged earner, okay, that is allowed to have a non-compete, I have to give them severance or monetary payment, okay? Now, that's assuming I am letting them go without cause, without cause, meaning it's not working out. Maybe they had some performance concerns, but I probably didn't document it right. So I'm just going to, let them go and say, you're at will, you're not a good fit. Okay. If you're not offering a severance, that non-compete is going away. Okay. Now, if they violated policy procedure, they were on a PIP, you've got a clear line of documentation and we are terminating for cause, the non-compete is a non-issue. It's going to still remain in effect. You don't have to give severance for that. It's only when we are separating without cause. So if you currently use non-competes, this is a great reminder that number one, we should have them audited as to who and who does not have a non-compete. Do we still need it? Can we still even use it for these positions or these peoples? Non-competes are very different from non-solicitation and non-disclosure agreements, okay? But again, a lot of times I see those all together in one document. Because of National Labor Relations Act, which is a federal law on the books that applies to everybody, as well as some of these Virginia changes, we also have to make sure that the non-disclosure and the non-solicitations are also properly worded. So if you're using non-competes, get it reviewed by an employment attorney. Like SESCO has employment attorneys on staff. We can do that for you. So you also need to ensure that any sort of severance agreement document that you have and release templates are consistent with the new requirements, as well as include National Labor Relations language, and they have been updated. Case in point, I had a client, granted they were in Pennsylvania, but she emailed me an old severance and release agreement that they've been using since 2018. Well, there have been so many changes since 2018 on a federal level, as well as in Pennsylvania, that she can't even use that document anymore. We had to completely rewrite it for her, okay? So make sure we're also not using non-competes as a default onboarding document. Minimum wage, again, currently $12.77. January 1 will be $13.75. It will be $15 as of January 1, 2028. After that, beginning in 29, then we'll go back to what we're already used to, right? Where Virginia Department of Labor will say, we're going to increase minimum wage by this percentage. They typically announce that late October, early November, prior to the end of the year. So, but that automatic adjustment is not going to start until January 1. So next year, $13.75 and then $15. So make sure that, again, we're updating budget, payroll systems, pay grades, because with this increase, we have to be mindful about ripple effects, right? Wage compression. Maybe I was making, $14 an hour while, minimum wage right now is $12.77. Well, January 1, I'm only 25 cents above minimum wage now. You're going to have a perception issue. You're going to have a cultural issue. So that wage compression, they're going to expect adjustments. Overtime, you're going to have higher overtime calculation costs. Make sure that we're budgeting for that. Make sure that we're, looking at our contracts, our pricing, our labor budgets. All of those things are going to have to be adjusted to, take into account the increase in minimum wage and our wage adjustments there. Let's talk a little bit about paid sick and safe leave. This is new. Okay. A lot of businesses already offer paid sick leave. That's wonderful. A lot of small businesses don't, and that's okay too, but we're gonna have to start offering it. There's going to be a phased coverage implementation here, so don't panic on me. This applies to both public and private employers. Okay. If you're a nonprofit, yes, you're still included in that. So anybody with 50 or more employees, your implementation date is July 1 of 27. On January 1 of 28, anybody with 25 or more is going to be covered. By January 1 of 29, anybody with at least one employee. Do not wait until your phase-in date begins to start planning. Okay. Don't do it, because you're going to have a policy. We're going to have to update payroll systems. We're going to have to train managers and our employees on how they're supposed to be tracking their paid sick and safe leave. And so don't wait until the last minute. Okay. It's going to be an accrual method. Okay. So I'm going to accrue 1 hour of paid sick leave for every 30 hours that I work a week. Okay. Now, if I'm part-time or per diem, where I may not work 30 hours until midway through the month, that's fine too. It's 1 hour for every 30 hours that I work. Okay. So I wouldn't get that 1 hour until mid-month. Okay. Whereas maybe I have somebody that's full-time that works 35 hours every single week. They're going to get that 1 hour. Okay. Uses. My own illness, my own injury, a health condition, mental health, or preventative care. I can also use it to care for a sick family member, immediate family member, spouse, child, parent. This leave is also going to include a safe provision. It's very similar to what we see in Maryland, Chicago, Illinois, Delaware, New Jersey. A lot of these states have implemented the safe provision. Okay, so Virginia's no different here. That includes me being able to take leave for domestic abuse, sexual assault, or stalking. Okay. This accrued sick leave is not required to be rolled over, and it is not required to be paid out upon separation. So, what do we need to do? Probably going to need to look at your current leave policies and make sure that they're going to be compliant moving forward. Okay. We've got to look at accrual, use reasons, I just said that it wasn't allowed to be carried over. That was a mistake. You can carry it over year, but they can never exceed 40 hours at any point in time of sick leave. Okay. So that was my mistake. And I wanted to make sure that I clarified that. Carryover is allowed, but not to exceed 40 hours per year. Now, if your policy already provides more than 40 hours, great. Maybe you need to look at carryover, that sort of thing. So we're going to have to look at your policy. If you don't allow carryover in your sick leave policy, you're going to need to update to reflect that. Okay. So implementation checklist here. Make sure you're checking your head counts and your phase-in dates. Let's look at your policy. Let's get that reviewed. Let's start brainstorming on what we need to do to modify that. You may need to look at payroll accrual codes, leave request forms, and managers. Technically, there is an option where you can front load it. Okay. If you don't want to deal with the carryover, you can front load it. You can prorate the front loaded for part-timers. Okay, but you're going to have to generally estimate when they're going to hit those 30 hours and do the appropriate adjustment for the front loading there, right? And make sure that, again, managers are trained. We can't retaliate against using protected sick leave. This is a big one for Virginia, paid family medical leave insurance program. Now, again, very similar to what surrounding states, Maryland, Delaware, DC, are already doing. Okay. It was only a matter of time before Virginia mirrored those. Okay. So Virginia is going to establish a state administered paid family medical leave. It's an insurance program. Okay. It's going to apply to all employers except public sector, except for employers of the actual Commonwealth of Virginia. Okay. So this is going to be benefits that employees pay into to the state via payroll deductions. And depending on our size of the organization, we as an employer are also going to be paying into this state insurance program. Okay. So it's payroll premiums.
I had a question. If they're operating in several different states, does the sick leave only apply to hours worked in Virginia?
Well, yes, it's only going to apply to employees that are working in the state of Virginia.
Okay.
Yep. That would also include remote workers. So we're going to start in 2027 making these payroll premiums, and then employees are going to be able to start receiving benefits as of December 1 of 28. Okay. So here is the contributions and payroll plan. let me get in front of this already. No, I have no idea what these payroll rates are going to be. Okay. Department of Labor and the VEC, that's the Virginia Employment Commission. That agency is actually going to be the one handling all of these insurance claims, just like unemployment, right? They're building out the program. They're building out the systems, they're building out the forms and the policies and the templates. We don't have any of that yet. They haven't set the rates yet, so we don't know. I anticipate that sometime between late October, early November, that they may release those. Okay. And when they do, we will be notifying all of our clients of that. So if you have 10 or more employees, payroll contributions are going to include both your share as the employer as well as the employee share. If you're under 10 employees, okay, I am not, as the employer, paying a premium to the VEC. It's only going to be the employee having that money automatically taken out of their paycheck. Okay. Now, again, deductions cannot reduce us below minimum wage requirements. And so again, this is going to be one of those things that we're going to have to update our payroll processes, finance, HR. Everybody needs to look at systems and procedures and make sure that all of that is updated before the benefits begin. Okay. So we're going to monitor VEC. As more information comes out, we will let you all know. I can take PFML for these reasons: birth of a baby or bonding after the birth of a baby, adoption or foster placement, caring for a family with a serious health condition, taking paid leave for my own serious health condition where I can't perform my job functions. There is also military caregiver qualifying exigency leave and safety related leave for domestic violence, sexual assault, and stalking. Okay. Now, again, remember, this is an insurance benefit. So if the employee has one of these covered reasons, they're going to go file that claim with the VEC. Okay. It's going to be on the employee to, submit the claim. Now, the VEC likely, if I'm anticipating like they do it in other states, the VEC is likely going to send us as the employer some sort of verification. When did they start work? How long have they been there? What is their current rate of pay? What is their job title? So on and so forth. So there likely will be employer participation and verification, but it's not going to be the same level of monitoring like we would have normally with federal FMLA. Okay. Now, the benefits and job protection. Just like federal FMLA, if you're over 50 employees, you're already familiar with this. But for some of my smaller groups, this is going to be a big change, right? So again, 12 weeks of paid leave in a benefit year for covered medical reasons. If it is a safety-related reason, domestic violence, sexual assault, stalking, they get up to 4 weeks for safety-related reasons, okay? Typically, the benefits are going to be about 80% of what their average weekly earnings would be. That's going to be subject to a statewide cap. Again, don't know what that cap is going to be. This is where the state FMLA is going to be different than federal FMLA. Okay. Federal FMLA, we're used to, they have to, be employed for a full year before they're eligible. That's not how that's going to work here in Virginia. 120 days. They only have to be with us for at least 120 days before they can apply, and they have that job restoration and job protection right. Okay. Just like with federal FMLA, they go back into the exact same everything. It's like they were never gone. Their job is protected. Their benefits, medical, dental, vision, still remain in effect while they are on FML. Okay. So big change. Again, this program is being built out. And so we don't have a ton of information other than the framework of the law itself. Don't forget, state FMLA, federal FMLA, Americans with Disabilities, our company leave policies, workers' comp, short-term disability, long-term disability, all of these things run fluid, okay? They run concurrent. So while state is going to provide wage replacement, it does not eliminate your requirement, if you are a large employer, to still comply and follow federal FMLA. So you're going to have to designate federal FMLA as well. Okay. Remember, this is just the paid insurance benefit of it. Okay. There may be situations where workers' comp and short-term disability, FMLA, and ADA, all of it's running concurrently. Okay? There may be ADA accommodations for light duty work or return to work provisions that also run concurrently with this. Friendly reminder, always do your fitness for duty, stay in touch, have solid documentation, stay in front of it. One of the largest areas of liability that I see on a daily basis with clients is FMLA situations where somebody's already gone out and either FMLA was not issued because, and I quote, the employee didn't ask for it. That's not how that works. Or somebody filed a workers' comp or they're on short-term disability and we just assumed that was all we needed to do. Absolutely not. You have to have templated letters, approvals, medical certifications, touch points, tracking of attendance, tracking of, how much time they've taken, how much time they have left available, intermittent time, all of the things. So if you have individual questions or concerns about that, we can dig into those specifics of your particular organization and make sure that you have the correct templates, forms, and tracking systems in place. There will also be obviously notices and documentation required. State right now does not require a state FMLA poster. It will. I don't have the poster yet. Okay, hasn't been released. But that's also going to require update to your employee handbook. If you don't have a handbook, you need one. Claims procedures, anti-retaliation, training on managers, so on and so forth. So we're going to, as we get closer to that date, that December date, or well, actually April, because we're going to start making contributions in April before December. We're going to need to do some training and modifications to processes there as well.
We had multiple people wanting to know if PFML is going to take the place of short-term disability.
No, it does not replace short-term disability. That is something that as an organization, you may want to look at. If some businesses offer it as an optional add-on through like an Aflac or a Lincoln or, a carrier like that. Whereas other employers pay 100% of it and offer it as a, automatic option for that. Now, when we get into paid state FML, remember it's a max of up to 80%. Short-term disability could also run concurrently. Let's say you offer short-term disability. That short-term disability, that policy would then cover the remaining, 20%. So those things are going to run hand in hand together. It's a great question. And I would say the same thing about any paid leave that they may have available to you as the employer, right? They may have to exhaust all of their paid leave available, so you can use any paid leave to make up that 20% difference. Or, maybe I'm making well over what the state cap is going to be. Then we're taking the PTO to, give them their full whole paycheck. And then once they exhaust that, then short-term kicks in. What if I have somebody that's making $250,000 a year? That state cap is probably going to be like $1,000 a week or less. Okay. That is way lower than what that employee was bringing in. So don't necessarily, assume that we don't need short-term disability anymore, because you likely do. Now, I mentioned earlier in our time together that sometime by May 1st of 2028, VOSH, which is our state-run OSHA, is going to have to create a heat illness regulation. Okay, that's going to look at both indoor and outdoor heat exposure. And we anticipate that the requirements are going to include specifics about required water breaks, shade, climate control environments, practical rest periods, training, emergency response plans, and high heat procedures. Okay, now high heat, as they noted in their regulation, is going to be anything 80 degrees Fahrenheit or higher. Okay. Again, I don't know what the standards are going to look like yet. I have seen other states do this, so I have a general idea of what typically it might look like, but that doesn't mean that VOSH will go along with that. So I don't want to speculate too much and give you misinformation, but just know that these regulations will be coming down the pipeline. Okay. This is really important for a certain number of industries, right? Automotive, field service, restaurants, utilities, warehouses, manufacturing, landscaping, construction. Even if we do have internal environments or indoor environments, we're going to have to make sure that that indoor environment has, appropriate air conditioning. And we would still likely have to comply with the rest periods, the emergency response, so on and so forth. So they'll also look at short duration exposures and emergency response. And so we will keep our eyes on that, and we will notify you all as we go along and get closer to that 2028 date of what those regulations are going to be. So I know I threw a lot at you in a short amount of time, but it's really important to kind of get back with, decision makers, HR owners, leaders within the organization, and look at our implementation calendar. Okay. Do a wage and hour audit. Make sure that our job postings are updated. Make sure our processes, if you don't have a comp plan, it's a great opportunity to get one. Audit those non-competes, have those reviewed, make sure that they are correct. Start preparing and modifying paid leave policies. Okay, so that your handbook is ready to roll and we can get that reissued prior to the July 1 of next year. And then keep checking your emails, pay attention to the SESCO updates for that VEC and VOSH safety guidance and paid FMLA guidance as we go along. Okay. Don't forget manager training. That is a big priority. Managers need to know what the changes are, what the rules are, the policies are, what their role is, and notifying and working alongside with HR or office management or leadership. Give them talking points for interviews. Make sure that they are not asking about compensation history. No retaliation. That's really important. Again, all of these laws have anti-retaliation provisions in them. Okay, so plain language talking points and make sure that we're all on the same page there. Okay. With your documentation, signed written pay plans for anybody that is earning an incentive. Okay, signed, dated, we vetted it with legal. Get those good faith ranges and be able to show, where did we pull this data from? Okay. How did we interpret this data? How do we use this data? How do we make sure that there are, it is fair? Again, that goes back to having a good formal compensation program. Check your applications, modify those appropriately. Check your careers page, modify those appropriately, and update those interview materials. Okay. I mentioned the legal review of non-competes and severance and release agreements. We can assist with all of these things. And then as the required posting notifications come about, make sure that we get those posted and that we are communicating with our employees about these changes. long story short, this was a big year for Virginia. A lot of changes. I expect that more will obviously be coming in 27 and 28. So it's not just, you know, a 1 year thing. We've got other things hitting. But when in doubt, pick up the phone, shoot over an email. If you are enrolled in the Bearing client program with SESCO, you have telephone and email access to us. If you are unfamiliar on whether you do or you don't, or would like to get enrolled, reach out to your rep at Bearing, and we can talk about how to make that happen for you. But I can't undervalue the importance of good, clean documentation. It is the only thing that protects us. And keep up to date with things. If you have questions, let us know. We would be more than happy to look at options to assist you in all of the policy and legal reviews and wage and hour audit aspects there. So Emily, I am going to turn it back over to you. Do we have any final questions?
Yes, we had a bunch of questions. A lot of them got answered.
Okay.
Let's see. Someone wants to know whether the non-compete was for all employees, whether non-exempt or exempt.
It's all about the amount of money that they're making. So whether they're non-exempt or even salaried exempt individuals under that annual threshold, that dollar value, are not allowed to have non-competes either.
Okay.
It's a good question.
And I also had a question, the other one. Hold on. In addition to providing paid sick days, do you also have to provide paid sick leave moving forward if you're less than 10 employees, or is that required paid leave paid for by the state?
I think that question is blending both the paid family medical leave and paid sick leave. Paid sick leave is going to apply to all employers. There is the phased in based off of the size of the employer, but you are going to have to provide paid sick leave. The paid family medical leave is also going to apply to all employers, but if you are under 10 employees, the company does not have to pay into the state insurance program.
Okay. Rebecca wanted to know, in terms of listing compensation, how often you recommend having your plan updated? Should it be every year or every other year?
That's a great question. I think it depends on what part of the state you're in, truth be told, as well as industry. Because let me use healthcare for an example. Healthcare positions, the market yields a much more aggressive and rapid change compared to a non-clinical type position or a non-healthcare organization. Again, that's where we get into regions, right? So Shenandoah Valley, all the way down to Southwest or even Southside Virginia, Danville, Martinsville, that area. Their market is not going to be changing as rapidly or changing as often as like a Richmond, Charlottesville, Lynchburg, Nova, beach area. Okay. If you're out on the Eastern Shore, that's a pretty stable market there. So I would say if you are in a larger area, I would absolutely do it on an annual basis. If you are in, valley down, and you're more in a rural area, you can probably get away with every 2 years. But again, remember, it's got to be a good faith effort, right? It's got to be a good faith range.
All right. And then Colleen wanted to know, how might wage transparency impact paid internships, if at all? We don't actively advertise them, but we post on our website for potential openings, and we'll review any emails on a rolling basis.
If you're posting on your website for a potential opening and it says paid intern, you're going to need to post the range for that.
Okay.
Yeah.
And if you have combined sick and PTO,
Yeah.
will you need to split them per new legal requirements?
No, not necessarily. I've had that question a lot. It's more about looking at what your current PTO offers and making sure that the accrual or the front load of that current PTO is obviously going to meet the statutory requirements of at least the 40 hours for the paid sick. And let me give you an example here. Let's say that I get 8 days of PTO a year as a brand new employee. Okay. So I can use that for whatever I want. But now with this new law, I know that I have to give at least 5 of those days designated to sick only, which only leaves me with 3 days if I wanted to go on vacation, take time off for my kids' school play, whatever it may be. And that might be fine for your organization based off of your size, your industry, your location. But what we need to take into consideration is the perception of those 8 days, right? So I had 8 days that I could use. I could take 5 for vacation, and maybe I save 3 in case I'm sick, but I'm relatively healthy and I don't take off for sick time. But now you're telling me that I only have 3 days to use for actual vacation, right? So it becomes a cultural piece, a perception piece. So you're going to want to look at your current accrual rates and how those would be, pulling out the 5. What does that leave them with? And do we need to up our accrual so that they maintain the same intent of having, 5 days of vacation, 10 days of vacation, in addition to the sick? You may be comfortable with where it's at, and the chips fall where they fall. But you should absolutely look at the total number of hours that they're accruing to make sure that we've got enough to cover at least the 5 sick days per year.
Again, I think you maybe answered this one already, but Jen and Jeff want to know, can you front load salary, PTO, and sick time and then accrue hourly?
Yeah, absolutely. Absolutely. But
Yeah.
but your policy is going to need to be very specific about that.
Okay.
And making sure that payroll is set up correctly. So that certain things are front loaded and then accrued correctly as well for everybody else. Yep.
All right. Any more questions that I may have missed that did not get answered? Asking you. No. Oh, we have one. Stacy, she asked earlier, but I don't know if I phrased it properly. She wants to know if they have employees working in multiple states, does the sick leave only apply to hours worked in Virginia?
So it has nothing to do with hours worked. It has everything to do with where the employee is performing the actual work.
Okay.
Okay. So if I am doing work in Virginia, hours would have to be tracked legally by wage and hour laws. So let's use a good example. I live in West Virginia, but my company is in Virginia and I work in Virginia. I'm covered.
Okay. Angie wants to know if it's mandatory that all employees participate in PFML or if they can opt out.
No, it's mandatory.
Okay. And then
There is no opt-out provision.
Robin wants to know if you could
Unfortunately.
clarify the questions in regards to asking about salary expectations again.
Simplest way, based off of the job posting and based off of the requirements of the job, this position pays between blank and blank. Okay. That range is going to be based off of, education, experience, so on and so forth, however your job description is written, the requirements of the job. Okay. Does this meet your expectations? Yes or no, period. So the job is posted between this and this based off of the requirements. Does this meet your expectations? Yes and no. And while we are also talking about that, here's my HR best practice. I talk money. It's like the third question that I ask in the initial telephone screen. Why? Because I don't want to take somebody through a process in order to, after a couple of times meeting or maybe twice, make them a job offer. And they're like, oh, wait a minute, I thought it was going to be $20,000 more. So I always talk money up front. Emily, are there any other questions that came through?
I'm just getting some clarification on one that
Okay.
someone just asked. I think maybe they missed a word or two. They said, what about salary time payment? If they work less than 40 hours, are we required to pay them salary, or can we reduce by employees are doing this every week? I don't know what they were
I'm
trying
not
to ask
sure I
there.
understand that question. So what I would recommend is that they give me a call or shoot me an email separately, and we can talk about that offline.
Okay. Stacey had a follow-up to her question about working in multiple states.
Okay.
If they're a West Virginia corporation, but an employee works 20 hours in Virginia and 20 hours in West Virginia during a single week, what happens? And for purposes of working 30 hours for 1 day of sick leave, how is this calculated?
It's a good question. I would anticipate, because again, you have to keep in mind, Dolly has not issued any of the actual oversight requirements of PSL, paid sick leave. They've just simply enacted the law. Department of Labor is still building out with the compliance, the enforcement, the best practices, the FAQs, all of that. They might, I find it hard to believe. My guess is they are going to look at just total hours of work, regardless of where that work was performed. They might provide a carve out where it's only hitting hours of work in Virginia. I find that hard to believe. None of the other states around us have done it like that. So my anticipation would be it's 30 hours altogether, because they're working in Virginia, even if it's only, part of the time, it's the 30 hours. Once they hit 30 hours, it's that 1 hour.
Okay. And then Thad, he wanted to know how to get your information in order to contact you.
Yep. Austin or Emily will provide my email signature in the follow-up, but feel free to email me at Jamie, Jamie, at SESCO, SESCOMGT.com.
Okay. Any other questions from anyone? Not seeing anything come in.
Right.
Oh, wait,
Awesome.
Brian, you can ask your question. Okay, Ruth says, we normally have a probationary period before benefits kick in. Will that have to go away?
It might have to go away for certain benefits.
Okay.
Because remember, when paid family leave kicks in, it's going to be 120 days. Most people's introductory period is anywhere from 60 to 90 days. I would anticipate with the sick leave, they're going to mirror exactly what like Illinois and Maryland and Delaware did, where they start accruing on day one, but they're not eligible to take it until after 90 days for the paid sick leave. That's what most states do, New York, New Jersey, all of them. So my guess is that Virginia is going to follow suit. Without knowing what his specific introductory period is before benefits kick in. We may, have to carve out the sick leave from everything else, but also with health insurance, it can't be anything longer than 60 days eligibility anyways. So 90 days. So we can look at your policy and see if it needs to be revised.
Okay, Brian's question is, if an employee physically works 30 hours in 1 week and takes 3 days vacation, are we allowed to give them an option on whether they are wanting to use their vacation time if they had overtime the previous week in the same
No.
pay period?
No, that is considered compensatory time in lieu of paying the overtime, which if you are a private employer, comp time is illegal and will get you in a lot of trouble with the Department of Labor.
Alrighty. Any other questions? I don't think I missed any.
A lot of great questions.
Yeah, there's a lot.
Again, you can absolutely reach out to me individually to ask any follow-up questions, whether it's about this or any other HR related topic.
All right. Well, thanks everybody.
Thank you guys.
Thank you, Jamie, for hosting.
Absolutely. Have a great day.
All right, bye.